Thank you, everybody, for joining us today for our Illinois Cannabis Roundtable. Before I get started, I need to cover a bit of housekeeping first. The information presented in this roundtable is meant for guidance purposes only and is not as professional, legal, or tax advice. Further, it does not give any personal tax, legal, investment, or business advice in general. With that, I would like to introduce Darren Grady and Daniel Sabet as our roundtable speakers. Darren serves as the co-chair of his law firm's Cannabis, CBD, and Hemp Service Group, Amundsen Davis, founded its cannabis practice in 2013, making it the first large full-service law firms openly to serve the cannabis industry. Since then, Darren and his partners have advised clients on just about every legal hurdle cannabis industry members face, including licensure, employment issues, litigation, acquisitions, real estate, intellectual property, and more. Darren and his colleagues publish on cannabis topics frequently and have presented at a variety of industry and bar organizations. The team at Amundsen Davis works with dispensaries, infusers, cultivators, manufacturers, distributors, and entities with connections and business relationships in the exciting and emerging industry. Darren is an experienced litigator in Illinois, often defending large national corporations against personal injury, contract dispute, and discrimination claims. Our second speaker is Daniel Sabet, a senior manager at Green Growth CPAs with nearly 2 decades of experience in accounting. He brings a wealth of knowledge from his tenure at the Big Four accounting firms and within private industry. Daniel leads Green Growth CPA's outsourced CFO section, overseeing a substantial portfolio that includes more than 75 clients across 12 states, providing them with the essential tools to incorporate accounting fundamentals, navigate financial and tax compliance regulations, and set and achieve financial plans for sustainable business growth. With that, I would like to welcome Daniel and Darren to our presentation and hand off to Darren for the first section. Welcome, Daniel and Darren, and thank you so much for joining us.
Thank you, Warren, for that nice introduction. We're excited to have everyone here today, and I'm going to kick things off with sort of a general discussion of where we're at from a legal perspective in state legalization, federal prohibition, and what the government's doing to potentially remedy some of the issues that we have with that problem, the dichotomy of state legalization and federal prohibition. So I'm going to start sort of very basic. I realize that our audience here today may be a little bit more sophisticated, so I'm going to fly through some of these earlier slides and focus on the CAOA and safe banking, what's going on in Illinois, and then touch on FDA and EPA approaches before we get into things like corporate structure, financial contributions, tax and accounting issues that Daniel will speak expertly on. So getting right into it, you'll hear me oftentimes refer to cannabis, using that word cannabis as opposed to marijuana. Marijuana is still colloquially used, and even in some state legislation and initiatives, the term marijuana is still used. Typically, those within the industry use the term cannabis because it's a more scientific application or discussion of the plant. And there are growing concerns that the use of the word marijuana has some pejorative context to it, as the governmental bureaucrat who led the cannabis prohibition effort almost 100 years ago. This gentleman named Harry Anslinger, he really positioned cannabis, or marijuana as he called it, as something that would be a threat to the white community, and it was being introduced to other communities. On the previous slide, there was one of his quotes, which I will not repeat, which sort of states his position on why marijuana, as he put it, was not a great thing for society. So you'll hear me refer to the plant as cannabis. Moving on, cannabis can be referred to any aspect of the plant, and obviously we'll talk a lot about the well-known cannabinoids of THC and CBD. I'm sure most of you here know the difference between THC and CBD. Although we're getting into this Delta 8, Delta 9 issue where those lines are being blurred, and I think many people are thinking they're buying CBD when they're at one of the shops, and then they get some Delta 8 and they do have psychoactive effects. But there's a whole nother talk on that issue and the loopholes that people are exploiting there. So if we move forward a little bit, we can talk about where things are in terms of state legalization. Obviously hemp has been legalized by the Farm Bill in 2018. Hemp is a variety of the cannabis plant with a THC concentration no more than 0.3% THC by dry weight. By virtue of the Farm Bill, people can now move industrial hemp through states which do not allow for the growth of industrial hemp. And that's another big hurdle for cannabis that does have higher than that requisite THC concentration, right? Even between two state legal states, cannabis cannot be shipped. That's one of the issues that many state legal cannabis operating businesses are clamoring for the government to fix, along with banking and obviously the descheduling or rescheduling of cannabis. Hemp is its own beast and probably the subject of another talk, but we're talking here today on operating cannabis businesses. So let's talk a little bit about state legalization status. With each passing year, more and more states come online, either with medical and or state recreational programs. Now just over 30 states and Washington, D.C. have decriminalized cannabis or outright legalized it. We've got a map on the next slide, which when I last updated this presentation in May needs to be updated again because Minnesota on this map should now be orange. They are now legal recreationally. The states in gray, it's almost easier now to list states that have no favorable laws towards cannabis than it is that do. So you'll see the smattering of states that are gray with no formal legalization or highly restricted access to cannabis and cannabis related products, including two of our neighbors here in Illinois, being Wisconsin and Indiana. A special welcome to any of you who are from either of those states, as we see increasing numbers of individuals leaving those states to cross into borders to gain access to cannabis, including people in Wisconsin going now to Minnesota, the Upper Peninsula, and to Illinois to get access. So, each few months I update this, the map changes. Many people think that this year Florida and Ohio may institute some sort of recreational program, and then more states to consider that moving forward in 2014. So it's safe to say now that in more states than not, there is access to cannabis of some sort and a growing access to recreational cannabis like we have here in Illinois. Moving forward, these are just a list of states where medical cannabis is legal, listing them out rather than in map form. So we could jump ahead to a discussion of, what's going on, state by state. There are nuance. Every state's different with respect to their legalization framework. Virginia's still getting up and running. Minnesota is still getting up and running. And even within those states, there are different laws, regulations, nuance that one has to be aware of. The most curious of which being Washington, D.C., which does not it has legalized the possession and use of cannabis, but not the sale. So you have these businesses that pop up where you make a donation or you buy something and then you get cannabis gifted to you. So if you're moving from state to state as a cannabis consumer, or you're looking at states where you want to operate, it's important to really know the state by state law. It's not enough to know that, hey, rec is legal here, medical's legal here. I know the way they do it in Illinois. That must be the way they do it in Michigan or in Delaware. It's all very, very different. So for those of you who may be affiliated with multi-state operators, you obviously know that. For those that may operate in one state and are looking to get to another state, it's important to have someone there that really understands the law, because the laws do change from state to state. So we can jump forward. Obviously, many of you are aware of the issues that are created when we have many states with different legalization laws, and federal position on cannabis, which is that it's still illegal and scheduled in Schedule 1 of the Controlled Substances Act. And that creates a lot of headaches for businesses that are legitimate and operating in compliance with state law. These roadblocks are multifaceted, including banking, interstate commerce, tax deductions, which Daniel will talk about in a little while here, and even preventing research into cannabis, although that is now being loosened up by the DEA. As with each passing year, we see more and more funds being allocated to universities or other laboratories who receive federal money to allow research, not only in cannabis, but now beginning to grow in the psychedelic space as well. It's also had ramifications with how the EPA and FDA deal with cannabis, and I'll touch on that here in a few minutes. So I wanted to talk a little bit about what's going on at the federal level with what is often referred to as the legalization movement, but more likely than not, if it eventually happens, when it eventually happens, will be either a end of federal prohibition or rescheduling or descheduling of cannabis. Momentum on this end has really been building since May of 2021, when various laws, including the Common Sense Cannabis Reform for Veterans, Small Businesses, and Medical Professionals Act, was introduced. But if we move forward on the slides, we're going to get into what is really, there are two proposed acts that have the most momentum on the federal level, which are really sort of moving out ahead of others, including the Cannabis Administration and Opportunity Act, which has been thrown out in various forms now for the last year or so, would lift the federal prohibition on cannabis and allow state compliant businesses to have access to financial services such as bank accounts and loans. And obviously that's a boon and a huge issue, because the cannabis industry has largely been prevented from banking any cannabis derived funds at all for any bank that's insured at the federal level. So there are state chartered banks that do it, some smaller banks that do it. This statute would not technically legalize cannabis, but simply end the federal prohibition, removing it from the Controlled Substances Act, where it still remains a Schedule I drug, which means that in the eyes of the federal law, it has no medical value and a high potential for abuse, despite the years of research that we have to say otherwise. Under the CAOA, individual states would retain control of cannabis policy within their borders, and states that would not legalize cannabis would have to allow for transport through their borders. It produces grant programs for those who have been affected over the years by draconian war on drugs penalty laws, provide funding, and help cannabis licensing programs to assist those disproportionately affected by the laws and resulting penalties to actually become participants in the industry. It also sets forth a federal tax structure. As we all know, states heavily tax cannabis, and with the passage of this law, or really likely any federal legalization or end of prohibition law, there would be a federal tax structure implemented as well. So they would get their piece as well. The FDA would take over as the regulating agency, which is now the DEA, and the ATF would also be involved with some regulatory oversight pursuant to the act. I'm going as quickly as possible as I can here, because I could talk about this stuff for an hour, and I know we have to get to some other things. So, the part of what seems to be holding the CAOA up are some of these criminal justice and social reforms. When we have more conservative politicians who are considering the act and recognize that there is a need to either reschedule, deschedule, or end the federal prohibition on cannabis, they are concerned that the social justice aspects, including expungement and criminal justice reform, are too liberal. That is an often debated aspect of this law, and tends to be sort of a hang up when we get into the political divisions on addressing the law. Recently I've read that the head of the Department of Health and Human Services has been taking a look at cannabis policy and is planning on issuing a report to the Biden administration by the end of this year, which it's anticipated will be pro descheduling or rescheduling of cannabis. So when we talk about timing, obviously we have the Biden administration who is open to it, has not come out directly in support of the legalization of cannabis, but it's largely a view that he's warming to it. So once he gets this paper and the remarks by the Department of Health and Human Services, it is expected that the administration will take a hard look at descheduling or rescheduling in 2024. So I although it's hard to predict, I would not expect any movement on descheduling or rescheduling this year. Potentially next year, we could see some movement. State legislatures are pressuring the government, lobbying groups are pressuring the government, and they know that something like this needs to be addressed. So if we move forward a little bit on the slides, we can get into what we're doing with the Safe Banking Act, which is more focused on the banking issues than the CAOA, which is a large scale and a federal prohibition act. At my last count, it's been passed by the House 7 times and prevents federal banking regulators from prohibiting, penalizing, or discouraging a bank from providing financial services to legitimate state sanctioned and regulated businesses or an associated business, such as a lawyer or landlord providing services to legal cannabis businesses. This act would greatly open up the world of banking services, banking products, loans, investments to otherwise legally operating state cannabis entities. And there's a lot of banking entities, a lot of investment companies that are not touching it because of the federal illegality. And a law like this one would really open that up for these otherwise legitimate businesses and really become a boon for the industry. It was largely when retail started and people started coming in and purchasing cannabis products, it was largely a cash only business, which was extremely problematic from a liability perspective and a safety perspective. There are more solutions now than ever, especially with state chartered banks and these transactions called PIN debit or cashless ATM, which is essentially an ATM that you use your debit card for, but you don't actually pull the cash. The cash goes directly to the business and they actually give you your ATM feedback. So there are workarounds making it less so, but there are many businesses that still operate cash heavy and would much prefer to proceed with safe banking. There were discussions. The Senate committee met in May of 2023, and I think now they're getting some pressure from different governmental entities like the Department of Health and Human Services to really get things addressed, at a minimum, to address the banking issues that these businesses continue to face. So those are the Safe Banking Act and the CAOA are probably the two pieces of legislation, if you're into this, that you want to watch. In particular, if you are an already operating cannabis business, the Safe Banking Act. So we can move forward from that. And obviously, if you have any questions regarding what's going on with the CAOA or safe banking, you can ping me on the side or pipe a question into the chat, and we'll try to address that towards the end of the presentation. I realize I'm going quickly. I wanted to touch, but before we move on to the next section, on how the FDA and EPA has historically approached cannabis. The FDA has been grappling with this issue for some time, and they've made statements along the way in the last several years, things like it's committed to protecting the public health while also taking steps to improve the efficiency of regulatory pathways for the lawful marketing of appropriate cannabis and cannabis-derived products. And they've set standards, and they've looked at things like food and drugs, and even cosmetics, and really where they got was that there are a handful of drugs now that have cannabis or cannabis-derived products that are specifically approved for very, very narrow in specific injuries, one of which is Epidiolex, which was approved for use for a very serious seizure condition, one or two seizure conditions that particularly affect children, and they've seen great results. But really, there are other than those, their approval of drugs, right, for using cannabis products are really, really narrow. And you see things like CBD products being advertised as doing certain things, helping with arthritis and pain and anxiety, and many of those companies, if they go too far with what they claim their product will do, they're going to get pinged by the FDA. And despite what you may see, there is no legitimacy to selling CBD for therapeutic or medical use. It's a violation of federal law. And you know, well, the one thing that they do allow for cannabis to be put into is things like cosmetics, which is interesting when they're not allowing it in food or drink. You know, we've all seen CBD infused cookies or teas or whatever in various shops. No matter what you see, that is not approved by the FDA, and still is not approved by the FDA. You know, dietary supplements are a no-go, but there are no regulations with respect to cannabis or cannabis-derived ingredients in cosmetics. They continue to grapple with it. You know, there really have not been a ton of enforcement actions unless you really make salacious claims like this is going to cure your cancer or something like that. And most recently, the FDA basically said, we don't have the ability to implement a regulatory framework for this. And they said that they would work with Congress on a new way forward. So as they continued to grapple with this over the years, they basically have punted to Congress, and then we're right back to where we were with respect to how would a statute like the CAOA, if passed, sort of rework this regulatory framework. In its current version, it does put it on the FDA, but they're relying on Congress to set some laws as to what can and cannot be put into food products, dietary supplements, cosmetics, things of that nature. So again, we're right back to where we started. The FDA really doesn't have a workable framework on other than to say we're working on it, and now we want to work on it with Congress. EPA, you know, obviously this is a crop, and many that want to grow the crop need to use things like pesticides or other chemical compounds to protect their crop. Because the EPA is a federal agency and cannabis remains a federally illegal product, there is no legal pesticide for use in cannabis farms. So that can be a problem if there is an issue with a particular crop. So it's another thing that needs to be worked on once descheduling or rescheduling happens. Illinois, which I think is where I'm located and where many of our attendees are located. We've got a rollout now for a couple years of adult rec retail program. More and more cultivation centers are opening, and Illinois, at least in the initial retail applications, they scored them very heavily if you had certain social equity components. Now, objectively, with respect to the licenses that were issued in Illinois for the retail, it really wasn't a very diverse group of license winners with respect to size of company and diversity of ownership. And they are attempting currently to right that wrong with a new round of 55 conditional social equity only licenses. That the slide says the retail lottery should have occurred in May of 2023. That has been delayed. They recently, just about 10 days ago, listed out the final list of lottery participants, about, I think, 2,700 companies statewide going for these licenses. And that lottery they say is finally going to happen in about 6 days. So all of those licenses will be issued conditionally, hopefully here in about a week. And then there will be a prove-up period where those businesses will have to show that they are in fact social equity operators, and then they can start papering the file, getting information to the IDFPR here in Illinois to make the conditional license an actual final operational license. And before I turn it over to Daniel for the next section, just a quick tidbit on the market. Back in 2022, $1.6 billion in adult use cannabis sales. And we're going to have more cultivation centers, more retail opening in 2023. So the large expectation is that those numbers will continue to grow, likely putting Illinois as the third largest market for adult use recreational cannabis by the end of next year. So I realize that's a lot for the first section. That's a very high level overview of where we're at in Illinois and federally. And I think we're gonna switch now to the next portion of the agenda.
Awesome. Thank you so much, Darren, for that overview. It was very informative. What I want to touch on are strategies for contributing capital in a cannabis operation. Creating a C Corp is the best option, especially when dealing with a social equity applicant. I'll touch on this more when I dive into corporate structures, but just wanted to lay out the framework there. Contributions of capital are best served with a minimal amount of common stock and the remaining amounts in the form of a loan. So ideally, as an example, if there's a $1 million investment that's made by owners, you want to keep as little as possible in that common stock. It could be $100, $1,000, something very, very minimal, just so you have something on the books, per operating agreements. And then the loan would be the remaining amount of capital that's contributed. Reason for this is this way owners who contribute capital can get their original capital back from operations without it being a taxable event. If they were to contribute this entire amount to a C Corp, it would be stuck in the corporation, and the only way owners would be able to get that money out is in the form of a dividend, which would then be taxable to them individually. As far as loans go, there must be an interest rate attached to them. So there's, that's something that's pretty strict. IRS is definitely auditing that. One catch there is that interest expense is a non-deductible cost to the business, so it does hurt the business in a sense that it gets charged, it goes to the owner, but then the business is not able to deduct that, which gives it a higher tax liability. So you want to be able to charge as little interest as possible in accordance with the IRS federal applicable rate. In the current market, that rate is somewhere between 3.85% to 4.8% annually, depending on the term of the loan. They have short-term, mid-term, and long-term loans. Usually short-term is 3 months or less, mid-term being over 3 months, less than a year, and then long-term being more than a year. So that's where those ranges come. I remember back in 2021 when interest rates in the United States were very low, this applicable rate was extremely low as well. It was south of 1%, but now it's been adjusted. On the IRS website, if you look up federal applicable rate, every month they come up with new updates. So whenever that loan is created, you want to use it based on that month. It's really important that loan agreements are in place, and highly recommended that you have an attorney draw up those documents to ensure that they are compliant. As far as social equity considerations, I wanted to talk about how social equity partners are involved and what the potential exit is for them. As you guys know, social equity partners, they have to have at least 51% ownership. So it's 51% or more. Typically, we see them at the lowest possible, which is the 51%. And from our experience, when they're involved, there's usually an option for them to get bought out, and they tend to stay on board for an interim period of anywhere between 1 to 3 years. After that period, it is usually a mutual agreement that they would exercise that option, and a third-party valuation would be conducted, and the buyout price would be based on the fair market value at that time.
Daniel, if I could jump in, and that initial period, at least in Illinois, when There is oversight by the state regulators. It is very important to have your social equity owner actually involved in the operation and management of the business rather than just someone on the ownership structure. That is something, I mentioned earlier that there were some difficulties in how the original social equity applicant scoring was done, and then how businesses that earn the initial retail licenses actually implemented their social equity partners. Illinois is attempting, at least on the surface, to cure those issues with this later round of social equity that we're about to have a lottery for. And it's our prediction and our expectation that the state regulators will be checking in with these new businesses to make sure that at least in the initial period, those listed as social equity owners are actually involved in the operation of the business. There is no prohibition of selling the social equity license to a group that does not have social equity applicants, but the longer that business operates, the more legitimate it seems. So it's just something to consider. I think for the most part, the days of throwing someone on there to earn the social equity points and get the license and then immediately phasing them out are gone. But the longer that person operates, and even if they continue in as a management or even as an employee after they're phased out as an owner, will be something that the regulators will be looking at in our prediction.
Absolutely. Yeah, and I was going to get to that where also it's more beneficial for the social equity partner to be involved and potentially receive a salary, because from what we've seen, their payout is a long-term process. They'll be on the license, have the percentage, but most of the money that's coming in would go back to pay back that loan that the owners who contribute capital would get. So their form of payment would be in the form of a salary, working in the business. So for example, in a retail operation, they might be the manager getting X amount of salary per month in charge of the day-to-day. Same goes with if it's a cultivation or processing, we'd hope that they'd be involved. They have that experience from the past and can help, whether it's being on top of the grow or being some sort of administrator, salesperson. They would be very, very involved throughout that process. And I guess the idea here is that in those 1 to 3 years, that's when the operation would hopefully cash flow. That money would go back to the owners who contribute capital, and then by year 2 or 3 or around that time, that's when all those loans will be paid off, and now they're able to generate money for the entire company, and then they can split the money pro rata based on the percentages after the buyout. Yeah, so that's what we've seen in the past. There's some situations where the social equity partner does have those special skills that would attribute to partnership. They might even contribute money themselves, in which case, if they do the buyout, it might be a partial buyout where they can shore up the economics. So rather than being a 51% owner, maybe there's 3 partners involved and they'll be 1/3, 1/3, 1/3. Some sort of dilution would occur in that case.
All right, shall we move on to the next part of the agenda, corporate structure and real estate positioning?
Yeah, absolutely. So yeah, a lot to talk about here. So with corporate structure, based on our prior experience, we've observed that it is prudent to break out cannabis operations and real estate into 2 separate entities due to cannabis being federally legal. As I mentioned earlier, from a tax structuring standpoint, cannabis operations should be set up as a C Corp, and this is due to several reasons. C Corps, they provide the utmost liability protection from the IRS compared to those pass-through entities, such as LLCs and S Corps. So the way it's done tax-wise is the C Corp submits a tax form 1120. They pay the tax on the corporate level, where the LLC and the S Corps, or even if it's a single member LLC, it would be a Schedule C. Those are all information returns that flow to the personal level, and the resulting profits, along with that 280E liability, would flow down to that personal tax of the owner. And this is a very big sticking point. You know, we've had clients who are used to being S corps because they have their own small businesses, but the fact of the matter is that, you know, the IRS this is a very audit friendly industry, and you never know what's going to happen in an audit. There are certain deductions that you can't make, that they might do add backs, and, you know, there might be potential gross negligent penalties. And if that's to happen, we want to make sure that it stays at that corporate level, that it doesn't affect the owners who are involved.
Yeah. Then Daniel, if I may jump in, just not knowing the knowledge that our audience may have on 280E. Obviously one of the biggest concerns of the industry is how to open, how to get compliant, stay compliant, and then become a profitable business, right? It's a challenging business. You see a lot of businesses that operate and they just break even for a period of time. So the IRS recently, or over the last few years, has been directed to aggressively enforce 280E, which sometimes can result in an audit that could make an otherwise break even or profitable cannabis business on paper not profitable when the large tax bill is assessed. And if you're not ready for it or prepared for it, it can be a real gut punch to your operating business. And essentially, and this is sort of a distillation of 280E, but it's a federal tax code provision that mandates legal cannabis companies can only deduct the cost of goods sold or the expenses in producing cannabis, which would then go on to exclude costs that are commonly associated with distribution, sale, admin, management, promotion, advertising, and overhead as allowable deductions. Deductions that other businesses, if you have a hot dog stand or a paper company, or that you might otherwise be able to deduct. So it's a hugely problematic provision, and it's really important that when you set up your corporations, as Daniel has been talking about, that you take those considerations into account. So that's what Daniel means when he's talking about being concerned with 280E and taking that into consideration when you set up your corporations to run your business.
Exactly. Thank you for that. And one misconception people have is with C corps, they feel, okay, they're getting the liability protection, but in exchange, they're paying higher taxes. There's this myth about taxes being so high because of the double taxation. But the fact of the matter is, when President Trump was in office and he implemented the Tax Cuts and Jobs Act, he lowered the C corp rate on the federal level from 35% to 21%, which is a huge difference. And in most cases, that's considerably lower than the personal rate of business owners, their effective rate on the one tax. And even if, let's say, we paid out all these loans and we haven't done the sale yet, and dividends are distributed, we could structure those as qualified dividends where they're only 15% on the personal level. So when you look at it effectively, the 21 and the 15% being about 36% total, that's very comparable to what the effective tax rate is on most business owners, depending on what state. But yeah, we usually see people, their effective tax rate on the federal level is 35, 36, 30, up to 40%. So in some cases you're actually saving, in other cases you're breaking even or just a little bit above. But the liability protection makes all the difference there. Now C corps, they can be structured in a manner where contributions, distributions, and the ultimate exit can be achieved with minimal tax impact. In order to break this down, it's important to understand this business cycle, because each business, they have 4 stages. The first stage would be the formation and contribution of capital. Second stage would be the ongoing operations. Third stage would be the distribution of initial capital and profits. And then the final stage would be the exit through a sale or merger. So to break this all down and the whole tax flow, where the minimal tax impact occurs, going back to what I said earlier, owners will contribute majority of the capital in the form of a loan, charged at minimal interest. In ongoing operations, as income is generated, taxes are paid at the corporate level, and then the excess funds are used to pay back the owner loans. Those paybacks are going to be non-taxable since they're the original capital contributed. Distributions are made minimally as owners need additional cash for daily expenses, and we would structure that as a qualified dividend at the 15%. And here's the biggest value point. The sale of the company would result in a capital gain to the owners, but this would mostly be wiped away by Section 1202, the Qualified Small Business Stock Gain Exclusion. This is a huge, huge benefit here. Under this exclusion, a shareholder of a qualifying C Corp can receive up to $10 million in tax-free gain on the sale of their business. Now, there are several qualifiers, but the main ones are that the stock needs to be held for at least 5 years after issuance. The total assets cannot exceed $50 million on the date it issues the stock, and 80% of the entity's assets must be used in the qualified trade or business. So someone who wants to be in this business for 5 years or more, they build it up, get a good valuation, sell it off to an MSO or to a hedge fund or private equity company. They can really cash out and avoid all that tax by keeping, limiting their distributions, getting back their loan, doing this entire process. It's a huge, huge benefit.
Yeah, and if I may say, when we look long term for some of these smaller businesses and what the end goal may be, for many of them, it may be to get up, operational, compliant, maybe even break even, maybe even be slightly profitable. And then when descheduling or rescheduling or the end of federal prohibition happens, you will have large, very, very wealthy corporations all of a sudden looking to enter the market and scoop up licenses and businesses. And if you are a compliant business operator and you have the corporate structure and these tax benefits already baked into your business, you will be a more appealing candidate for acquisition, and the acquisition will be better for you in the long run, if that's what you want to do. Now, you may want to maintain your small business and be a competitor, but there are a lot of clients that we've served are, look, this is a long game. This is a long game for us. And if federal prohibition ends, we will look to get the value of our business appraised and sell it to the highest bidder. And if you have things like Daniel was just discussing in place, it will only benefit you.
Absolutely. Now, moving on to the real estate entities, this structure is a little different from a tax structuring standpoint. The real estate entity should be set up as an LLC. So if it's a single member, it would just be a single member LLC that fits on the Schedule C. I'm sorry, the Schedule E in this case. And if it's a multi-member LLC, it would file a 1065. And the reason for this is with a real estate company, there's the ease of contributing and distributing assets from the entity, the ease of taking advantage of a 1031 exchange if you were to sell an asset and exchange it into a new one. And generally, the income from real estate is considered passive. So that rental income, it's not an active income that would be subject to self-employment or payroll tax. So you wouldn't be subject to that Social Security and Medicare that can add up to 15.4%. Now, the way the real estate entity should operate is that they would then lease out the real estate to the operator at a fair market value. And that would be a rental expense that would be partially deductible based on how we structure it. If it's how much the square footage is in respect to operations versus sales versus admin. Additionally, we've seen in past experience that the fixed assets, things like the leasehold improvements, the equipment, the furniture, and the fixtures, sometimes they're owned by the real estate entity and sometimes they're owned by the operator. And what we've seen from a tax perspective, that it is more beneficial to have these owned by the operator rather than from the real estate entity, because they're the ones that are going to be generating the majority of the income, and having these assets on their books and using the bonus depreciation can wipe away a lot of the tax liabilities in those first few years, and that would result in more cash flow to help build the business. Another thing that happened during the Tax Cuts and Jobs Act was that bonus depreciation was implemented, and we've taken advantage of that over the last several years with our clients taking 100% bonus depreciation. That's starting to scale down a little bit. It's in 2023, rather than being at 100%, the bonus depreciation is now at 80%, which is still a significant amount, but it has scaled down a little bit, and it will continue to scale down by 20% over the next 4 years until it's eliminated. So we definitely want to take advantage of that as much as we can over the next few years. And then after that, we just have to take it as like a straight line, which is still not as beneficial, but still pretty useful. Okay, should we jump into the next section? Very good. Okay, so financial planning and projections. A couple touch points here. It is important for cannabis operators to know their projected income and expenses. A cannabis tax professional such as Green Growth, they can help figure out their taxable base and what they need to set aside for taxes, each year and each quarter. One thing that's important here, and I know Darren touched on this a little earlier regarding 280E, but according to that IRC code, cost of goods sold can only be deducted in the business. Selling, general, and administrative expenses cannot. But what we do is we utilize Section 471 of the IRC, where we can reclassify portions of those certain expenses into cost of goods sold and come up with an adjusted taxable base. So with this, we use several different methods. There's a square footage method that we use for a lot of expenses, such as rent, utilities, softwares, licenses, things of that nature. And then for payroll, we'll do an analysis of how much of the payroll is involved with plant touching versus non-plant touching, and come up with a percentage on that. And then we'd move those back up to cost of goods sold while leaving some of them in expenses. And that way you can understand what your taxable base is. It's not that net income that you have. It's actually the gross profit, which is the cost of goods sold, subtracted from the top line income. And then based on that number and based on the depreciation that we would assume, at year end, we'd come up with a number that's their taxable base, and then now they know how much money to set aside for taxes. And as we're doing financial analysis each and every month, we can pretty much figure out what percentage of their gross sales is set aside for taxes. So that way, as they're making money, they can each day say, okay, I made $10,000 today, and it was told to me that 10% of our sales is a tax expense. So now I'll put $1,000 aside, make sure I don't use it for anything else. So when that tax liability is due, we're in a position to pay it. Understanding cash flow for the business is vital to its survival. We've had many operators that would not monitor this closely and use money they should have set aside to pay tax obligations, to purchase new inventory, or spend it on marketing or something of that nature. And this would result in a buildup of tax liability and then them just falling into a rabbit hole that they simply can't get out of. And then what happens is when they're in that rabbit hole and they can't meet those obligations, now it's just an exponential effect. Additional late penalties and interest will pile up as a result, and it'll just be an uphill battle for them. Managing cash early is key in this case. As a manager of the CFO team, we have different services. One of them at a higher scope of a service is that we would provide our CFO clients with tracking that operating cash flow on a 16-week basis. So that way you can kind of look ahead and see what are your main obligations that you got to pay, and and how you can meet those obligations while at the same time putting money back in the business to purchase inventory and continue to grow it.
Wonderful. Thanks, Daniel. I think we've covered a lot of ground in 50 minutes now, and obviously most of this is very high-level discussion. So as I said, when I was speaking earlier, if there are any specific questions that either Daniel or I can help with, we can certainly address them in the chat, or you can reach out to us privately and we can start a dialogue. Outside the context of this roundtable, I think at the close, Warren will provide our contact information, but we do have a couple of questions that have come in. One of them is a question I get asked a lot, and is Illinois really committed to diverse ownership and social equity as a long-term goal in the industry? That is a great question. And I guess the easy answer is the one I like to give is it remains to be seen. Right? They obviously had some challenges with the first go around on the retail side. When you look at who got the licenses, even when they were social equity applicants, that is a challenge that I know the state regulators are trying to address with this next round. Right? And this next round, there were no applications even available to non-social equity applicants. Now, what remains to be seen is once those conditional licenses are awarded and the oversight begins, will the state hold the applicants' feet to the fire in the process of them actually showing that they are social equity applicants and that the individuals who make up the social equity component of ownership are actually involved in operating the business, right? First step, we'll see who are these the lottery participants who get pulled. Are they able to show that they actually qualify? And then will they be able to actually operate as social equity businesses? And then what oversight will they have if these social equity licenses begin to get sold or transferred? Right? It remains to be seen. It's encouraging that this next round is only social equity. Governor Pritzker has talked about rectifying the issues that they've had with the implementation of the social equity program. I remain hopeful that they'll create a space in the market for the more diverse ownership, but it remains to be seen. And I realize that's not a great answer. I would like to tell you, yes, they will. It is a commitment and a goal, but administrations change, governmental agencies change, and historically Illinois does Illinois things to industry, and corruption and cronyism and things like that tend to leak in, and people want to skirt the system. And I remain hopeful that social equity will remain our priority, and not only as a stated priority, but actually in implementation. Let's see. There's one other question which I think I can try to answer is when will the laws be changing for banking? I am hopeful we see some sort of banking resolution by the end of this term of Biden's administration. I think it has the most momentum now, and the closer we get to a potential regime change could throw a monkey wrench into any progress being made. It's difficult. It's difficult to predict that, because seemingly it's difficult for the legislators to get anything significant done. But I think there is some bipartisan support on the banking issue, and there is increasing pressure from lobbying groups and state governments who want their state compliant businesses to get the access that any other so-called legitimate business may have to banking products and banking services. So I would expect that sooner than any sort of rescheduling or descheduling. But given what's been going on in the last few years with respect to legislative progress, it's tough to predict. But that one does have more legs than descheduling. And finally, I think Daniel and I can both give our opinions on this last question that has come in as we sort of near the completion of our hour here, what are the issues, the long-term, or the issues, the biggest issues other than legalization facing the cannabis industry? And this question also referenced the edibles industry specifically. Outside of legalization, I really do think it's navigating the financial pitfalls, many of which Daniel touched on, right? Protecting yourself from an unexpected large tax bill, making sure you're aware of cash flow and how your business ebbs and flows, and how you can maintain a profitable business that is also regulatorily compliant within the jurisdiction that you're operating in. The last thing you want is something going on in your business that jeopardizes your license, because really that's the thing that allows you to be in this industry, and without it, you can't be in it. And once you lose it, extremely difficult to get it back. You don't want to be subjected to fines levied by the state for violations and warnings and censure, while at the same time trying to be able to pay your employees, pay your rent, and put away enough money so that if you do get a large tax bill, that you can survive it, right? Survival to me, especially for a first-time entrant to the market and a new person or entity entering the cannabis industry, is the biggest challenge. I think as the industry becomes more robust and we get more people using cannabis, I think you're going to see more litigation, in particular on the edible side. You've seen some litigation out west already where people claim that they were improperly educated as to the dosage of the edible or the potency of the edible or what it would do. These people, they take a little bit, they don't feel anything, they take more and more, and then all of a sudden they're doing crazy things. I think there's one case out in California where the estate of a family of a guy that ended up jumping off a balcony while on edibles sued a company for products liability and improper advertising and consumer fraud. That case, I think, settled out of court. But I think you're going to see more of that come, because with any industry, right, that has as much money behind it and as much revenue behind it, you're going to get lawyers who are going to specialize in suing that industry and trying to get their piece off of it. You see it with, dram shop litigation, alcohol-based sales. Obviously, the big cigarette lawsuits that happened years ago. You've seen some vape liability, products liability, exploding vapes or vapes that are causing injuries to lungs. So I think you're going to see a more diverse litigation practice once this industry has grown some deeper roots. So I think Daniel probably has some thoughts on financial and accounting challenges. But from my perspective, that's where we're going. Daniel, I don't mean to interrupt. I know I can't hear you right now, so I'm not sure if the other attendees can hear you. Still nothing. Well, yeah, it might be sort of just a technical issue, but we're at the tail end. If you have questions, or if Daniel, if you have questions on what specifically Daniel had in response to that question, shoot him an email. I think Warren is going to put our emails up at the end. You can also shoot me an email, and if it's Daniel's wheelhouse, I'll flip it to him. He's much more well-versed on the tax and accounting side than I am, and that's why we partnered together. I want to thank all of you for joining us. Again, let us know if you have additional questions. I know we move very quickly. I think a big takeaway, and when I get follow up from things like this are, I'm in the industry but struggling, or I want to be in the industry. What do I do? And I think it is very important to attend talks like this and learn about some of the pitfalls when you're first getting started out, and to work with people that know the law on the financial, tax, and accounting side, and on the legal side up front, rather than to try to strike it on your own and then try to fix potential issues after the fact, because that's where it becomes more problematic and more operationally difficult. And if you can do that, if you have the ability to do that up front, it's really a good way to start your business, to start your venture into this really exciting industry that's growing all around us. It's pretty rare to be operating and practicing in an industry where the laws form around us, where policy forms around us, and you have to adapt and move. It's really a special time to be in this industry, as many of you know. And if you have questions about how to navigate some of those changing laws and the issues as they evolve, as laws pass on state and federal level, folks like Daniel and his colleagues at Green Growth and myself and our team are here to help. And our goal really is to be a partner for you, to help launch your business into the stratosphere success-wise, make you real stable on a corporate, legal, tax, accounting level, so you can do the fun stuff like interact with your customers, your business partners, and take your brand and your business to the next level. So thanks so much for joining us. Let us know if you have questions. I hope to hear from all of you in some way, shape, or form. And we're here to help if you need us. So thanks very much for jumping on with us on a Friday, either morning or afternoon, depending on where you are. Hope you have a great weekend, and hope to hear from you soon.
Yeah. Thank you, everybody.